As a criminal defense attorney who runs a firm, handles a lot of criminal defense cases throughout the state of Washington, I get a lot of questions about, hey, what's going to happen? I got police contact, police officers came and talked to me, or I was arrested and taken to jail but then released, or I was arrested, or they talked to me and they said, I might receive something in the mail. What's going to happen? I have family, I have work, I have a life, I have vacation plans, I have things going on. How will I know whether or not a criminal charge is going to happen or not? And unfortunately, the answer on that one is nobody knows until a prosecuting attorney reviews the facts that the police officer presents to them. And as with any bureaucracy, this takes time. And there are variables in that are unpredictable. Police officers take vacation. Prosecuting attorneys take vacation. Their office loses staff that take vacation. And so identifying exactly or giving a really even better than a rough estimate of time is impossible. And so what you'll typically hear criminal defense attorneys say is, well, it depends on the statute of limitations of the crime. And I'm going to go a little past that definition, but let's explain what that means. A criminal defense, the statute of limitations it's a legal concept. It's a term of art. And what it means is that anytime you're going to sue somebody or you're going to be sued, there is a period of time in which someone has to take action. You can't be charged with, let's say, public intoxication and have a public intoxication event happen, and then 20 years later, the prosecuting attorney decide to get around and charge you anymore with a DUI. With lower level offenses, the statute of limitation varies depending on the crime. And so, for example, a misdemeanor in the state of Washington, the statute of limitations, the maximum amount of time somebody can wait on a misdemeanor is 1 year. On a gross misdemeanor, which is the next level up of lower level crime, the statute of limitations is 2 years. As you move up past that into felonies, it starts depending on the seriousness of the felony, graduating eventually to the most serious felonies, for example, murder, where you hear cold cases being opened 30 years later. There is no statute of limitations, for example, on murder. And there's only, I believe, 6 crimes right now in the state of Washington where there is no statute of limitations. So it just depends a little bit on your charge. The issue that's floating out there that I guess gets a little deeper into that topic is there's a catch-22. If prosecutors wait till the very end of the statute of limitations to decide to file against you, you have rights. And one of those rights is if somebody decides to wait for an unreasonable period of time to get around to charging you, and then you can prove that that is in some way prejudiced your case. Somebody on a gross misdemeanor, they waited 1 year and 364 days before they charge you. And the evidence that you had, the vehicle that was there has been destroyed, a witness died, evidence that you collected was destroyed. When you start getting into how you can prove that unreasonable period of time of waiting has prejudiced your case, you actually start putting together a good argument that the judge should decide to dismiss your case because it's unfair. And there's some legal reasons why, but the short answer is it's unfair. And so there is some pressure on prosecuting offices to take action and not let cases wait unreasonable periods of time before they file on it. In my experiences on misdemeanors, generally anywhere from a week to 3 weeks up to 3 months, gross misdemeanors as well, and that's experiences through various municipal courts and state courts up and down the Puget Sound region. It's somewhere a week to 3 months in general people take action. I have seen cases last out to a year when prosecutors were waiting because they wanted to know what an appellate court ruling was or a superior court ruling was that was going to affect their cases. And so sometimes in unique situations, they'll deliberately sit on a pile of cases to wait. And that just depends on your set of facts, and it depends what's going up through the appellate courts. And a criminal defense attorney who's attentive to these things generally will know what's going on, and that will affect cases in that way. When you get up into serious misdemeanors and you get into, or serious felonies, and you get up into cases that involve a lot of digital media or a lot of information that needs to be stripped off of computers and looked at, you get into crime lab issues on serious felonies. I have seen these cases take as long as 2 years before somebody gets around to charging you because they have an enormous statute of limitations on felonies. And it takes a while for their crime labs to go through the evidence in a way that's responsible and in theory doesn't violate any what's called chain of custody issues, where you start saying, well, who had my file and how do you know that what you looked at is what you took off from my crime scene, and where did it go and who did it touch, and are you certain that's the same file that you took from me? That's a chain of custody issue that is relevant when you're dealing with a lot of evidence and a lot of things that they need to look at, and that can affect how long a case can take to get to a charging stage or an arraignment stage. It's really important, I guess, that if there's one fact that I want to make sure that everybody follows through on is, one thing you don't want to do is you want to make sure that your driver's license, your Washington State ID, has a correct mailing address. Because if there is an arraignment at a future point, they will check and send a copy of it in general to that latest address. And so it's really important to keep an up-to-date address with them. Or as lawyers, we keep up-to-date addresses for our clients with the police department, or we also check some of the court records that allow us to make sure that arraignment hasn't taken place and our client hasn't missed it. It's not an exact science, but I think this gives people an idea of when they say, how long am I going to have to wait? You know, what's going on? I hope this kind of gives people a feel for, if you're waiting, what factors are in play.